I would like to acknowledge the Gadigal people of the Eora Nation, the traditional owners of the land from which I'm speaking today and which we now call Sydney, and to pay my respect to elders past, present and emerging. I want to acknowledge the vibrant and rich cultures, practices and traditions of First Nations communities that continues to enrich this country and which have been cultivated and practiced on this land for at least 65,000 years. I want to warmly welcome you all from wherever you're tuning in to the virtual launch event celebrating the publication of Volume 43, Issue 3 of the University of New South Wales Law Journal. I'm especially excited to open this event given this issue is the first and only thematic issue of 2020. It comprises 11 fantastic articles discussing the thematic topic, Revitalising Legal Authorities. The publication is a tremendous feat of leading scholars reimagining what the law could be. There are so many people I need to thank for their investment not only in this publication but also our ongoing work. I'd like to extend our gratitude to the Hon Robert French, Chief Justice of the High Court until 2017, for providing the foreword and the keynote address for tonight. As a sign of the times, he's delivered the keynote from Perth, and we're so grateful to our premier sponsor, King & Wood Mallesons, for generously hosting this launch in 2 of their offices across the country and across state borders. It's truly a testament to both the national and international presence of the firm. Our heartfelt thanks is also due to King & Wood Mallesons for the support of our ongoing work in publishing some of the leading legal scholarship in Australia. Without your support, our work at the journal simply wouldn't be possible. Thank you to Kelly Mildred, Sarah Morrison, and to Katrina Rathie, partner in charge at the Sydney office, for very generously making herself available to welcome us to the firm. I want to highlight the work of issue editor Inderpreet Singh. It's no overstatement to say that this thematic issue would not exist without her incisive vision in generating and bringing this thematic topic to fruition. Thank you for your continued vigilance and tireless commitment to the role throughout this year. I'm tremendously lucky also to have worked with our ferociously rigorous editorial board, who have been so generous with their patience and good humour despite all the changes of working remotely. Thank you to the university for your unwavering support of our independent, rigorous publishing standards. Thank you to our faculty advisors, Professors Rosalind Dixon and Gary Edman, and to our acting dean, Professor Andrew Lynch, who has kindly made himself available to deliver the vote of thanks. Finally, but definitely not least of all, a huge thank you to the academics who entrust us with your work. The publication of this topic would not have come at a timelier occasion as we look forward to reconceptualising authorities in Australia's legal landscape, and to recover from the social, economic and legal impacts of the pandemic. Thank you to all of the authors for your contributions which inject our understanding of the law and the sources of legal authority with renewed vigour and a fresh perspective. We hope that for the viewers at home, this publication and the conversations tonight, including the Q&A session after the keynote address, are enlightening and encourage a prospective view on the possibilities of what the law could be. I will hand over now to Katrina Rathie, partner in charge at the Sydney offices of our premier sponsor, King & Wood Mallesons.
Thank you, Antonia. I'd like to also start by acknowledging the traditional owners of the land on which we're gathered here today in our various locations on YouTube, which for me is in the strangest of years, is the Gadigal people of the Eora Nation. I pay my respects to elders past, present and emerging, and to any First Nations people joining our stream today. I'm Katrina Rathie, the partner in charge of King & Wood Mallesons Sydney office. King & Wood Mallesons is very proud to be the premier sponsor of the UNSW Law Journal. We have a long association with the Law Journal, which dates back some 39 years, which surpasses even my very long tenure here, which started when I joined the firm as a UNSW Commerce Law graduate in September of 1985. I can assure you that I was a child prodigy. I enjoyed my time at UNSW so much so that I convinced my firstborn son, Jack Rathy, to study commerce law at UNSW, and he graduated last year before coronavirus. We are a mother and son combination who both drank the Kool-Aid and now work at the firm. I'm also a proud member of the UNSW Law Advisory Council and have enjoyed getting to know Professor Andrew Lynch, Acting Dean, during the pandemic. I'd like to publicly acknowledge the stellar contribution of the former Dean of Law and now Deputy Vice-Chancellor for Planning and Assurance, superstar George Williams, AO, who has been recently promoted to steer the university through the strangest and most difficult of times. UNSW has chosen wisely. I very much enjoyed working with George immensely and giving the Dean's address to the law students last year. As a member of the UNSW Law Advisory Council, I attend meetings and receive regular feedback from UNSW and know that 2020 has been a particularly difficult year, with COVID cutting deeply into the finances and enrolment. Despite this, everything's good with the law school, and I was so pleased to hear that you've gone from strength to strength and now enjoy a ranking of the 14th best law school in the world. So go UNSW. Congratulations to Andrew and the fabulous team, faculty and students at UNSW Law. Over the 25 years that I've been a partner at King & Wood Mallesons, we've employed a large number of summer clerks and graduates from UNSW. I think we have over 150 lawyers from UNSW working in our Sydney office, mostly remotely and flexibly now, and they're all such wonderful people. Many of your alumni have gone on to become solicitors, senior associates, partners, managing partners, chairs and leaders at KWM like me. KWM values our long-standing relationship with the prestigious UNSW Law Journal. Many of our lawyers have been editors over the years. The firm is supportive of the important role of legal academia and how the law has been and can be revitalised to introduce new vigour or direction into the law for future practice. The theme of this year's issue is Revitalising Legal Authorities. I remember that my final year law school exam in intellectual property, which became my signature field of practice, was aptly titled Old Wine in New Bottles. Jurisprudence is evergreen, and the evolving nature of the law means that it can be reshaped and revitalised for our ever-changing times. I'll leave you in the very capable hands of current editor Indrapreet Singh and former Chief Justice of the High Court of Australia, the Hon Robert French, to discuss the delights of this year's issue 43.3, which includes purpose-based governance, intersectional discrimination, whistlebots, and even advancing reproductive rights, quite a topical subject in lockdown. It sounds like fascinating reading. Congratulations on the virtual launch from your premier sponsors at King & Wood Mallesons. Thank you.
Thank you, Katrina. Before I begin, I too would like to acknowledge the traditional custodians of the unceded land on which we meet, the Gadigal peoples of the Eora Nation. I would like to extend my respect to elders past, present and emerging, and to any Aboriginal or Torres Strait Islander peoples joining us tonight. 3 years on from the Uluru Statement from the Heart, we still have so much further to grow as allies to First Nations peoples, and I look forward to the day when the demands called for at Uluru are met. To all of our guests behind the screen tonight, I would like to extend a warm welcome to the launch of issue 43.3 of the UNSW Law Journal. Thank you all for tuning in to the second virtual launch event of 2020. While I had hoped to celebrate this occasion with you all in person, I'm grateful to have this opportunity to mark the coming to life of this issue in the COVID-safe manner we have now all become accustomed to. We are very humbled to have the Hon Robert French providing the keynote address tonight. But before that, bear with me a few moments as I introduce the theme of the issue and give thanks to all of the people without whose efforts the publication of this issue of the journal would have been impossible. While each issue of the journal is undoubtedly special, I have myself always had a soft spot for thematic issues. The opportunity to shape academic discourse in the way that thematic issues so allow is a unique and exciting one. So I am beyond ecstatic to present to you this thematic issue of the journal, comprising 11 articles on the theme Revitalising Legal Authorities. What this theme has ultimately been concerned with is encouraging ideas out into the open for the betterment of legal authorities into the future, to put aside existing assumptions and look forward to what could be. There are two key ways in which this theme could be and has been interpreted. First, there is scope to revitalise the law in areas of novel conceptual or practical development. Just as we would not use floppy disks for all of our newfangled technological needs today, some argue very persuasively that we cannot use old law to regulate our interactions with never-seen-before objects and issues. Second, there is scope to revitalise the law in areas where the progress of time has made law and reality dissonant. As Collier has put it, what makes a case decided in 1409 good precedent for determining who is liable from a leakage from a gas burner installed in 1929? Now, some have told me that lawyers aren't necessarily the most creative or innovative type, but I beg to differ. The careful thought reflected in the articles published in this issue is proof of it. To name only a few, the articles in this issue cover debates of significance and contemporary relevance, from calling for the interpretation of legal instruments to be undertaken by reference to international human rights law, to calling for the domestic enactment of Article 19 of the International Covenant on Civil and Political Rights to better provide for freedom of speech to Australian public servants, to demonstrating how purpose could better existing corporations' law principles and practice, to arguing for the need to build into the legal framework recognition of intersectional discrimination, and to encouraging the integration into parliamentary debate and legislation of Aboriginal languages, a process which I hope we can all agree is beginning much too late. This is the last fully thematic issue of the journal before we switch to an experimental publication structure next year, under which 2 general and 2 half-general and half-thematic issues will be published. As we bid adieu to our current format, we look forward to the exciting new content coming next year, with the first taste of thematic flavour coming in issue 44.1, due for publication in March 2021, comprising a thematic component on rights protection amidst COVID-19. And now for some thanks. First and foremost, I would like to thank the authors of the articles published in this issue, some or all of whom I hope are watching tonight, not only for their immensely valuable scholarship, but for also taking the theme in so many exciting directions that I had not even considered myself. I'm very grateful to have had the opportunity to work with you all, and I'm very grateful also for being the one to have seen your articles through to publication. I would also like to acknowledge the behind-the-scenes work of the anonymous peer reviewers who have taken their careful eye to each of the articles published in this issue and whose thoughtful comments have greatly improved the quality of the scholarship that the journal is able to publish. I would also like to thank our premier sponsor, King & Wood Mallesons, for hosting this launch event tonight, and especially for having worked so closely with us to create this wonderful digital alternative in light of current medical advice and gathering restrictions. I am especially grateful for the support that the journal receives from various members of the UNSW Law faculty. Most pertinently, a special thanks are deserving of our 2 faculty advisors, Professor Rosalind Dixon and Professor Gary Edmund. It is with their sage and thoughtful advice on matters big and small that the journal is able to maintain its place as a leading law journal in Australia. The support of the UNSW Law faculty more broadly, and our deans over the past year, formerly Professor George Williams and now Professor Andrew Lynch, is also invaluable to the journal's day-to-day running. Now, if you ever happen to get your hands on a physical copy of the journal, before flicking to what will no doubt be an interesting suite of articles, first, look inside the front cover. Why? Well, it goes without saying that the journal is very proud of its high editorial standards, standards which have resulted in many authors coming to me and saying this is the most rigorous and careful editing of any journal they have ever published with. This high standard is only possible because of the persistence, generosity and hard work of our student editors, the names of whom you will find on that very first page of the journal. This is all to say that I am so very grateful for the editorial board's efforts in editing this issue, and even more for the new friendships I have forged with them along the way. These last thanks are quite personal and are directed to those people whose imprint on the issue mightn't be tangible from face value, but whose efforts have undoubtedly shaped the issue and my editorship significantly. I would like to thank all the members of the Executive Committee that I have worked with over the past year for their unconditional camaraderie and good spirit in navigating the ups and downs of being an issue editor. I will admit there is nothing charming about the idea of an Executive Committee meeting on a Saturday, even less so when those are semi-regular commitments. But if there were ever a bunch to do it with, it would be all of you. And as we have joked in the past, and perhaps sometimes been serious about, I really only need 6 friends, and that is conveniently the number of other members of the Executive Committee. In particular, I'd like to thank Antonia, our wonderful executive editor, for her unparalleled patience, wisdom, humour and kindness. You've been a true friend and source of support, and the work that you do for the journal is often understated but should not be. And at long last, a heartfelt thank you to my mum, my sisters, my partner and my friends for all of their patience and support over the past year. I'm sorry that the only answer to your ever-present question, so what is it that you do at the journal, has been, it's complicated. And now, as I move into a more uncomplicated stage of life, I remain appreciative for all you do, day in, day out, to make my life the best it could be. Having said all that, I will not keep you any longer from the suite of interesting talks that await you, from Mr. French's Keynote Address to a thought-provoking question and answer session with some of the authors published in this issue. It is only fitting for me to now introduce more fully our keynote speaker. Mr. French has served as the Chief Justice of the High Court of Australia from 2008 to 2017. In a legal career spanning almost 5 decades, he has also served on the bench of the Federal Court of Australia, the Supreme Court of the ACT, the Supreme Court of Fiji, and also held other positions such as being President of the National Native Title Tribunal. At present, Mr. French serves as the Chancellor of the University of Western Australia. It is my absolute pleasure to hand over to Mr. French and invite him to provide the keynote address for this launch.
Well, ladies and gentlemen, it's my great pleasure to launch this special issue of the University of New South Wales Law Journal, albeit it's a virtual launch. It's not easy to discern and encapsulate the function of a book launch speech. Its presentation tests the speaker in more than one way. And in a real-life setting, if we were all together in the one room, there would be a motivational test for listeners. Why go to the trouble of sitting through the launch when there are drinks to be picked up and chat to be had about more interesting things? Fortunately, this edition of the Law Journal contains many more interesting things than this speech, reflecting, as it does, the exciting diversity of contemporary societal questions with which its contributors have engaged. An example of the interesting things in this journal, which should engage your immediate attention, is the piece by Yi-Fuen Ng, Maria O'Sullivan, Maura Patterson and Norman Whistleblowing, entitled Revitalising Public Law in a Technological Era, Rights, Transparency and Administrative Justice. Its discussion of the use of automation in official decision-making points us to a dystopian future of inscrutable exercises of statutory power by artificial intelligences, deep learning their skills through the discernment of patterns in big data and developing unreadable algorithms to apply that pattern learning to individual cases. The recent robo-debt disaster is a pointer to the downside of the efficiency benefits sought from the exercise of public power by or guided by machines. Moreover, legal accountability for automated exercises of official power may face some challenges. In a recent judgment of the full Federal Court, Pinterick and the Deputy Commissioner of Taxation, which is discussed in the article, Justices Moshinsky and Derrington held that a, quote, decision, unquote, amenable to review under the Administrative Decisions Judicial Review Act requires a mental process of deliberation. A passage from the dissenting judgment of Justice Kerr highlighted the problem. Quote, the expectation that a decision will usually involve human mental processes of reaching a conclusion prior to an outcome being expressed by an overt act is being challenged by automated intelligent decisions using systems that rely on algorithms to process applications and make determinations. So against that kind of content, this launch is a mere amuse-bouche, serving only to delay access to the feast. Of course, beyond self-doubt about the value of launch speeches, the presenter, like the forward writer, and I am both in this case, may face ethical challenges. Does the probability that few will take interest in the speech justify the presenter in skimming the contents page and the abstracts and making plausible references to randomly selected passages? As to that, I can say I have reviewed each of the pieces in this issue of the journal, and that leaves the problem of devising something appropriate to say about such a diverse collection. It's somewhat harder to reflect with an overarching comment upon what, on its face, is a heterogeneous collection of papers. There is, of course, a stock of well-used phrases to which any launch presenter can resort when desperate. So if you have a publication with worthy but turgid prose which is ultimately unreadable as a whole, you can use the term a rich resource. The publication that contains intellectually unsustainable propositions can be described variously as provocative, challenging or confronting, and for the truly tedious text, the anodyne thought-provoking may suffice, although the thought it provokes may be I have just wasted several hours in the twilight of my life reading this stuff. None of these phrases need to be deployed on this occasion. This issue of the journal offers a theme under the title Revitalising Legal Authorities. The editor's letter of invitation to write the forward and launch this issue told me that the articles explore how legal authorities may or have been revitalised to introduce new vigour or direction into the law and legal practice. And that rubric provides adequate accommodation for diversity, which is reflected in the selection of the papers. And truth be told, each of the papers engages with questions at the intersection of important changes in our society and in our laws. The first of them considers the interaction between international and municipal law in Australia, and the indefatigable Michael Kirby returns to the lists to joust with High Court jurisprudence and some of his former colleagues concerning the applicability of international human rights law to the interpretation of the Constitution and other legal texts. What the article throws up is the challenge in a dualist system of bringing international law, and in particular that aspect of it relating to fundamental human rights and freedoms, to bear upon the Australian legal order. His dissent in Al-Kateb and Godwin is revisited, and in that case you will remember the High Court held by 4 votes to 3 that the mandatory detention requirements applicable to unlawful non-citizens under the Migration Act permitted indefinite detention where the detainee could not be returned to the country of origin or a safe third country. The divisions among the justices were essentially interpretive, depending on differing views of the intractability of the statutory language. In revisiting the decision, Michael Kirby offers a tantalising glimpse into the small p politics associated with the circulation of draft judgments within the court. It may be doubtful whether we will see in the near future any change in the direction of the High Court's jurisprudence which would enable constitutional interpretation to be informed by international human rights law. But that said, a point of entry for international law or conventions into the Australian legal system, apart from specific adoption or application by statute, is through the common law. The rights and freedoms traditionally recognised by the common law reflect in significant part the fundamental human rights and freedoms which have become part of customary international law. And customary international law itself can be incorporated by adoption into the common law. And in that way, through the application of the common law to the interpretation of statutes, international law principles may be brought to bear on statutory interpretation. The topic is one of ongoing significance, and it is good to see it reactivated in Michael Kirby's article in his typically engaging way. In the second paper by Alicia Blackham and Jeremy Temple, the authors engage with one of the more difficult areas of discrimination law, discrimination by reason of intersecting attributes and vulnerabilities. That issue of intersectional disadvantage generally is a large and important one. In the Justice Project final report released in 2017, the Law Council of Australia identified 12 groups experiencing serious disadvantage in access to justice, a term defined broadly and not limited to legal advice and representation in tribunal or judicial proceedings. Those groups included people under economic disadvantage, homeless people, victims of family violence, Indigenous people, disabled people, recent arrivals in Australia and the elderly. And plainly enough, just by looking at that list, you can see that one person may be subject to more than one area of disadvantage or vulnerability and may suffer operational or intentional discrimination by reason of more than one of them. The authors in this article evaluate the extent to which discrimination laws accommodate the case of persons who suffer discrimination on more than one ground. They conclude that the problem is one which has to be addressed by law reform and a greater understanding by equality agencies of the extent of this complex phenomenon. They call for empirical analysis of its consequences, which fall heavily upon the most disadvantaged groups in our society. It's a useful contribution, not least because it reminds its readers to move out of a mindset that unconsciously puts discrimination laws and their enforcement into silos. Moving up to the big end of town, Vivienne Brand tackles the subject of corporate whistleblowing, and she considers the role of whistleblowers, whom she calls surrogate regulators, who don't necessarily inflict reputational damage on the enterprise for which they work. As she says, the regulatory role of the whistleblower may be just as important in relation to internal tip-offs that prompt corrective internal action as it is in the context of external disclosures to corporate regulators. From the role of the human whistleblower, she takes us to the technologically enhanced human interpretation and application of regulatory compliance requirements. This is brought under the unappealing sounding rubric of RegTech. RegTech itself, however, may have only a short time in the sun, for it is now, in her words, predicted to be disrupted by the arrival of AI-powered RegTech solutions that use predictive technologies and deep learning to facilitate improved regulatory compliance outcomes. Of course, it's from there only a short step to her suggestion that one day whistleblowers may be supplemented or replaced by what she calls whistlebots, with the ability to report autonomously within a corporation and or to external regulators and dramatically enhance internal corporate transparency. So where breach reporting by a regulator, to a regulator, is made mandatory, it's not beyond imagination that someone will suggest that risk is reduced if there is an AI to detect the breach and communicate it to a regulatory AI which can deliver the appropriate sanction within nanoseconds of notification. It's an interesting and forward-looking piece, and it should not be thought that the imagined prospects are unlikely to be realised in the short to medium term. Azadi Dastiari takes us in a different direction in her consideration of the fundamental freedom of expression evidently not enjoyed by Commonwealth public servants to the same extent as the rest of the population. She takes as her starting point the case of Michaela Banerjee, a public servant in the Department of Immigration who tweeted under a pseudonym thoughts critical of Australia's human rights record, among other things, and was dismissed for her troubles. The regulatory scheme under which she was dismissed was held by the High Court of Australia not to infringe the implied freedom of political communication, which, it will be remembered, is a limitation on legislative power and not a right or freedom vested in the individual. That case was a disturbing one, and the critique offered by Dr. Dastiari is thoughtful, making the persuasive point that the criticism of anonymous public servants has no more damaging impact on representative and responsible government than criticism from any other person in the Australian community. The article goes on to discuss international human rights law, and particularly Article 19 of the International Covenant on Civil and Political Rights and Article 10 of the European Human Rights Convention, and their potential application, if they applied, to cases such as that of Ms. Banerjee. From overspeaking public servants, we're taken to judges' law and the application of the principles stated in Australian Securities Commission and Marlborough Gold Mines Limited and Farah Construction Proprietary Limited and Sadie Proprietary Limited, that Australian courts in one jurisdiction must follow the decisions of intermediate appellate courts in other Australian jurisdictions on questions of law of national operation unless the other courts are plainly wrong. Now, if I can offer a personal perspective, the term plainly wrong seems to be more of an epithet than a useful standard. It may be reflective of the strength of the opinion of those who voice it, but sometimes little more than that. The article examines the development and practical application of the rule, and in particular how often it's been applied and where divergences in decision-making have emerged. Interestingly, in the 25 years surveyed, 20 decisions have applied the rule, 10 of them emerging from the Supreme Court of New South Wales. The purpose of the proposition is entirely legitimate: to encourage national consistency in the elements of what is properly regarded by reference to Chapter 3 of the Constitution as an integrated national system. The formulation of the test, in my opinion, however, leaves much to be desired. It's more likely to engender interjurisdictional resentment than a collective commitment to consistency across state and territory borders. The latter comes from considerations of comity and the desirability of uniformity in the interpretation of the law in a federation. That is to say, it's really a matter of common sense. Catherine Greentree explores the protean lineaments of non-statutory Commonwealth executive power and argues strongly for its interpretation through an historical lens, focusing on the common law and the historical prerogatives of the Crown. And in this, she joins the ranks of the late great Australian constitutional scholar, George Winterton, and his former colleague, Peter Urangelos. She critiques the High Court's approach to the non-statutory powers. As one complicit in that approach, I won't engage with the critique beyond saying that this article presents a helpful discussion for all engaged in advising or making decisions in this difficult area. As one who has never rejected the historical lens, I welcome it. The question for the future is how, case by case, will the definition and scope of non-statutory executive power emerge with greater clarity. The instrumental point of Ms Greentree's argument, reflecting those of Winterton and Urangelos, is that the prerogative can inform the process of delineation. It will be interesting to see when and to what extent non-statutory executive power again requires the attention of the High Court. Unlike Messrs Pape and Williams, there is not a long line of litigants seeking to challenge public expenditure by the Commonwealth in the exercise of non-statutory executive power. Rosemary Langford provides two pieces on corporations. The first is entitled Purpose-Based Governance, a New Paradigm, and that directs attention to the legitimacy of the corporate pursuit of purposes other than the maximisation of profit. As she observes, the topic has been the subject of debate for a number of years. Corporations espousing socially progressive positions, such as concern about climate change, tend to attract denunciation from cultural warriors on the right, who seem to regard such activity as ultra vires. ASIC and a number of legal commentators appear to have taken a rather different view. In her first article, Ms Langford directs attention to proposals to give purpose more of a role in the corporate sphere. She points to perceived failures of company roles in society, leading to increased mistrust in business, and propositions for what she calls a radical reconceptualisation of business, encompassing changes to ownership, stewardship and regulation. Those proposals require companies to articulate their purposes not in terms of the production of profits, but in terms of the production of profitable solutions to problems of people and planet. The fiduciary responsibilities of directors should be centred on promoting the corporate purpose. So this is a debate whose time has definitely come. Certainly a concept of corporate purpose larger than shareholder returns may be in the long-term interest of shareholders. That which enhances public trust and confidence may also keep over-intrusive regulation at bay. The second piece by Ms Langford on a related theme is titled Use of Corporate Form for Public Benefit, Revitalisation of Australian Corporations Law. And she here analyses the feasibility of purpose-based companies from the perspective of our corporations law. She builds on the first article by providing detail of relevant aspects of the corporations law regime and focuses more particularly on particular issues that arise in the facilitation of such companies. She seeks to demonstrate that revitalisation of our corporations law to allow purpose-based companies is feasible and opportune and does not require a fundamental shift, particularly given the malleability of directors' duties. She sees this evolution of the corporate form as a natural adaptation rather than a radical reformulation. Moving to a quite different topic, Julian Murphy addresses the use of Indigenous language in the law and the legislative process. He describes and defends the trend towards Indigenous lawmaking in Australia and refers to comparative examples of multilingual parliamentary debate and legislation in Canada, Wales, South Africa and New Zealand. He concludes with a discussion of the interpretation of multilingual legislation. Issues which he identifies are the interpretive authority of an English language court faced with a non-English statutory text, and the way in which questions of irreconcilable inconsistency between multilingual text is to be resolved and weight to be given to Indigenous language in the statutory text. This issue, the notion of multilingual legal text, is of course not novel, nor is the problem of reconciling interpretations which are in tension with each other. The issue arises in treaties and in multilingual communities. In the United Arab Emirates, for example, laws may be found in both English language and Arabic texts. In Hong Kong, the recently enacted national security law, which has attracted much debate, has both an English language and a Chinese language version. Now, I've already mentioned the next article on revitalising public law in a technological era and in the context of administrative justice. The last article by Rolly Sifris, Tanya Penovic and Carolyn Henkels is concerned with the advancement of reproductive rights through legal reform, focusing on the example of abortion clinic safe access zones. The authors regard the introduction of safe access zones as a significant legal reform implemented across Australia to support and promote women's reproductive rights. In so doing, they draw on empirical research conducted by two of them and consider that research against the background of the decisions of the High Court in Clubb and Edwards and Preston and Avery. Those decisions upheld the validity of Victorian and Tasmanian safe access provisions against the implied freedom of communication on political and governmental matters. They relate the High Court's findings on the constitutionality of the laws as reflective of empirical findings, particularly the proportionality of the laws to the legitimate objective of protecting the health, safety, well-being, privacy and dignity of Australian women. As they say in their concluding section, the law in most Australian jurisdictions has progressed to a position where abortion is viewed within the paradigm of health and medical treatment rather than within the criminal law framework. Not only has it moved to a health law, but laws have been enacted to protect women from those who wish to continue the discreditable but age-old practice of naming, shaming and blaming. There still, however, remain non-legal barriers to access faced by women seeking abortion in Australia. These are the areas of intersectional disadvantage, financial and geographic, and variability in practitioner attitudes and training. So the preceding overview of this collection lends support to the general rubric under which it is issued, Revitalising Legal Authorities. There are those who will select particular articles of interest to them. My own view is that it's well worth reading the whole thing to get a sense of the moving wavefronts of the law in intersection with societal change. The only thing you won't need to read after having listened to this launch speech is the foreword. Thank you.
Good evening. My name's Andrew Lynch and I'm the Acting Dean at UNSW Law. It's my great pleasure to give the vote of thanks to the Hon Robert Robert French for his remarks tonight in launching issue 43.3 of the UNSW Law Journal. Justice French recorded those remarks a few days ago at the beautiful Perth offices of King & Wood Mallison, and we also thank the firm for their sponsorship of the journal and for making available their Sydney offices for those of us on this side of the coast. Thank you, Justice French, for your generous comments on the quality of the journal and the academic contributions it contains, and also your recognition of the work of the editorial team, most obviously the thematic issue editor, Interpretive Singh. As Acting Dean of UNSW Law, I also want to acknowledge the remarkable contribution of our students to the publication of one of Australia's leading law journals, the UNSW Law Journal. As Antonia said in her opening remarks, the journal is an independent and student-run publication, and this is a source of immense pride to all the academics at the Faculty of Law. I wish to congratulate the special issue editor, Interpretive Singh, and also the executive editor, Antonia, and all of her team who have worked on the journal in this extremely demanding year that has been 2020. I thank our sponsors, King & Wood Mallison, but all other sponsors of the journal, and I hope you enjoy the Q&A that is to follow this evening. Thank you.
Thank you very much, Professor Lynch, for your very kind words of support, and thank you to all the viewers for tuning in tonight. I'll now pass on to Interpretive, who will introduce the authors participating in the Q&A session. We hope that you enjoy these conversations and insights into their articles.
Thanks, Antonia. We're very pleased to have, as we did for the launch of issue 43.2 in June, some of the authors whose articles have been published in issue 43.3 here tonight to speak about their articles. In spirit of the issue being a thematic one, each of the 4 authors participating tonight has been asked the same question, which gleans into how their article is related to the theme, Revitalising Legal Authorities. To begin, we are delighted to invite the Honourable Michael Kirby, former Justice of the High Court of Australia, among other things, to speak about his article, Municipal Courts and the International Interpretive Principle, Al-Kateb and Godwin. It's a real pleasure and honour to have you with us tonight. Mr. Kirby, if you could you please briefly sum up what your article is about?
This is the very central issue in my life as a judge, as a lawyer, and as a human being, and I'm asked to briefly sum it up. Well, I'll do my very best. The issue of the national law and international law is one of the big issues, one of the big questions that confronts municipal legal systems. It arises out of the world that emerged before, but especially after the end of the Second World War. At the end of the Second World War, brought to a final conclusion by the dropping of the atomic bombs in Hiroshima 75 years ago, the world had to address how it was going to prevent a similar catastrophe happening again. And this was under the constant pressure of the discoveries of the terrible abuses of human rights which had existed in the territories occupied by the warring powers, and especially the Axis powers. And so when the United Nations was formed, it established a committee which was chaired by a very great American and woman, Eleanor Roosevelt, for the purpose of drafting the Universal Declaration of Human Rights. Originally, it had been expected that it would find its place in the Charter of the United Nations, but they ran out of time. There were some objections by some of the countries at the table, particularly the Republic of China, and therefore they decided to take a bit more time. And the Universal Declaration of Human Rights was adopted in December of 1948, the 10th of December. I knew all this because I was then attending the Summer Hill Opportunity School in the public school system in Sydney, Australia. And I had a very good teacher. His name was Mr. Gorringe. And Mr. Gorringe had fought in the AIF in the Second World War in the Pacific region. He had seen dreadful things, and he made it his point to tell the young boys in his class, because we were then divided according to sex, that it was our duty to ensure that we did better in the future than his generation had done in the past. And he gave all of us a copy of the Universal Declaration of Human Rights. It was in a very small booklet. It was printed on airmail paper, which was lightweight paper. It had been sent out from New York, where the Secretariat of the United Nations was established. And all of us were given it, and we were taught about it. And so at a very impressionable age, I was then 9, I was taught about the UDHR. And I had actually seen Eleanor Roosevelt because she came out to Sydney to open the Repatriation General Hospital at Concord, which was built to look after American soldiers and Australian soldiers wounded in the war. And so I felt a personal connection with Eleanor Roosevelt, with the Universal Declaration of Human Rights, with Dr. Evatt, who was then Australia's Foreign Minister, and with the UDHR. And I was interested in its content, and we learned about it. And then I went to high school, and then I went to university, and then I became a barrister, and then I ultimately became a judge. And I was always interested in the UDHR because I remembered what Mr. Gorringe said: unless we can take this seriously, especially with the new weapons, we will simply destroy humanity. And I think it would be a good thing if all Australian school children could get a similar instruction. And in particular, those little naughty school children who go on to become judges, they might be a little bit more sensitive to the importance of and the contents of the Universal Declaration. Now, in 1988, I attended a very interesting conference organised by the Chief Justice of India in Bangalore, India. Ruth Bader Ginsburg, RBG, was there. She and I were the only judges there who were not on the final court, and we've been great friends ever since. And the judges who were present, most of whom were the Chief Justices of their countries, agreed with the Bangalore Principles. And the Bangalore Principles said essentially this: that international law is not as such part of our domestic legal system unless it's introduced, but it can influence the context of legal problems, and it can thereby find its way into the thinking of the judges in the development of the common law, in the expression of the meaning of ambiguous statutory law, and similarly in the understanding of a constitution where there are doubts about what it means. And this is not a very controversial proposition in most countries of the world, but it has proved very controversial in the two countries that Ruth Ginsburg and I came from. The United States of America thinks it's a terrible idea because they want to make America great again. And they think everything that's good came in the American Constitution. We don't quite think that, but we have a lot of people who are rather formalistic about the law and not inclined to take the contextual element of Universal Declaration of Human Rights. Anyway, I went back from Bangalore and I started sitting in cases where there was just no principle of the common law or no statute that dealt with the issue. And so a bulb would go off across at the top of my head, and that bulb would say Bangalore Principles. And so I would go out with my colleagues in the Court of Appeal, and we would look at the international principles and we would draw upon them for the purpose of filling the gaps. And at that stage, the High Court of Australia decided the Mabo case. And the Mabo case of 1988 had a very important passage in the reasons of Justice Brennan. He was then a Justice of the High Court, not Chief Justice. And he said that international universal principles do not of themselves become part of Australian law, but where there is a doubt, they can help to fill the gap. And that is Bangalore. And so my colleagues, Justice Clark in a very important case, Gradich, did this, and we found it was actually quite helpful to look at the developing principles of universal human rights. These are very clever judges in a lot of places in the world, and it was therefore useful in the development. It wasn't part of your law unless the judges made it part of the law. They couldn't bring a whole international treaty into our law, but they could fill gaps as they did in Mabo. And Mabo, the key that unlocked the door in Mabo to changing the horrible old principles of the common law, that the native title was not recognised, the key that Justice Brennan found. It's 175 CLR 1 at 44. And in that key, it said you can have regard to the universal principles of human rights in informing the development of Australian law. And so I've just been going along saying what judges in many countries have, but it causes heart attacks. And my dear colleagues in Australia think it's a terrible idea. And there was an important case called Al-Kateb against Godwin. And Al-Kateb against Godwin was a case about refugee law. And in that case, the High Court of Australia divided. Chief Justice Gleeson, who had come to the court by then, and Justice Gummo and I dissented. But I added a reference to the Bangalore Principles issue. And that is, I think, a very good illustration of how it can be useful to have regard to the universal principles as they are developing and to use them in understanding our Australian law. And in my article, which is a brilliant article, and the University of New South Wales Law Journal is so lucky to have it, it explains how I came at this, because if you understand the journey, you can understand how Australian lawyers who almost uniquely don't go on that journey need to understand that most lawyers in the world do go on the journey of universal human rights, and universal human rights can be helpful in developing our own legal principles. And I've sought to defend that approach in my reasons. RG has applied the approach in the Supreme Court of the United States, and judges everywhere in the world have done so. And there's a very good passage in my article in the University of New South Wales Law Journal, in which two of the judges of the International Court of Justice, our own James Crawford, who is a judge of the ICJ, and Judge Sir Kenneth Keith from New Zealand, another, have said that they think I got the better of the argument in Al-Kateb. But it's now a matter for the students and readers and the profession to consider this. For the time being, they have to obey the majority in Al-Kateb, but I herald Australia to a future time when the Bangalore Principles will not be controversial, and Australia will join the rest of the world. Make Australia great again. And we can do that by doing what lawyers everywhere do: have regard to international human rights law, at least as a contextual element in understanding our law.
Well, thank you so much, Mr. Kirby, not only for the overview of what your article is about, but that really interesting personal history of your own with human rights law in the UDHR. You've almost already answered my question, but I will pose it to you nevertheless. To revitalise legal authorities is to introduce new vigour into the capabilities of the law for future practice. How is your article related to this pursuit? And in what ways do you consider that the law can accommodate bigger and better things in the future?
Well, thinking bigger and better, how better and bigger can you think than if you think in terms of Australian law swimming in the sea of international law? and in the international universal principles of human rights. Now, that is really a very big issue. And whether you agree with me or not, I was going to say I don't care, but I do care. But whether you agree with me or not, this is a big issue. How Australian law relates. Do we just ignore the developments of international law? And I had a very clever thought, I think, that in 1920, a very important clever thought was advanced in Australia, and that was the thought which Sir Isaac Isaacs and Justice Higgins had, which ultimately in 1920 gained the majority in the High Court, that the way to interpret the Australian Constitution was to give full meaning to the provisions in the grants of federal power. And why did they do that? They did it because they too had come through a war. They'd come through the First World War. They'd come through all the dead that were killed and all the Australian dead who were killed fighting for the British Empire. And they came to realise, here we are in Australia, in the South Seas, in the Pacific, swaying palms and beaches, but rather isolated from the countries which were the countries that we shared our legal and cultural history with. And that's why Justice Isaacs had been preaching that we've got to give more power to the Commonwealth, constitutional power, and the way to do that is to interpret the constitutional power amply. And that was a contextual approach to an understanding of the Australian Constitution, had been triggered by the First World War. Now, what I'm doing is looking for a contextual approach to international human rights law, the universal law of human rights, triggered by the Second World War and by the atomic weapons and all the destruction and the Holocaust and the killing of so many people. You've got to learn in your journey in life, and that is why I think there is an analogy between that big change that happened in the engineers case in 1920 and my big change, which happened in a sense in the Mabo decision, but is argued in the Al-Kateb decision. And I think there's an analogy here, and it's certainly one to think of. Law is affected by context. Seeing an ambiguity is affected by context. And international human rights law is a very big context, and it would be a good thing if Australians who are not favoured with a constitutional Bill of Rights, and in most parts of Australia not favoured by a statutory Bill of Rights, but we are all part of humanity, and we are all assisted by Mr. Gorringe's little book, and it's the Universal Principles of Human Rights. It's not part of our law, but it can help the judges and the citizens to understand what their law means and how it operates in a particular context.
Thank you so much for that insightful response. It's no doubt a very interesting topic and of much significance to the future of legal interpretation in Australia. I'm very, very grateful for your time and for your thoughtful responses. And thank you so much for taking the time to speak with me today. Next up, we have Dr. Maria O'Sullivan, Senior Lecturer at Monash University, speaking on behalf of herself and her co-authors, Dr. Yi-Fei Ng, Professor Moira Patterson, and Associate Professor Norman Whitsleb, on their article, Revitalising Public Law in a Technological Era, Rights, Transparency and Administrative Justice. Maria, thank you so much for being here and taking the time to speak with me. Let's start by getting a brief overview on what your article is about.
Our article is looking at technological developments, particularly automated decision making, and how public law should respond to those technological developments. So, as some readers would know, public law, as we know it today in Australia, has been around since the 1970s. Obviously, before that, we had the common law principles, but the modern Australian administrative law really happened with the invention of the AAT, the Administrative Appeals Tribunal, and the Administrative Judicial Review Act, the ADJR Act in the 1970s. So we looked at the ideas behind those reforms, coupled with some general understood principles about what public law is all about: rationality, efficiency, transparency, accountability. And we looked at those fundamental institutions and principles, and we adopted what we would call a bottom-up approach. So that was the bottom level principles, the foundational principles. And then we looked also sort of top down, looking at international best practice standards. And I focused very much there on the Dutch case involving the Siri regime that was recently handed down, which took very much a human rights perspective. And of course, that's interesting because we don't have a federal charter of human rights in Australia. So that serves as an interesting comparator. So we brought all those things together. I brought, I guess, a human rights lens. My other co-authors brought their privacy knowledge, then freedom of information, and then also administrative law more formally, to provide a cohesive analysis of how public law should respond to these innovative issues.
Great. Thank you so much for that really detailed overview. I'm sure it's going to benefit a lot of the audience who mightn't have had time to read the article yet. It's definitely a very interesting topic. And if I may ask you a question now, to revitalise legal authorities is to introduce new vigour into the capabilities of the law for future practice. How is your article related to this pursuit? And in what ways do you consider that the law can accommodate bigger and better things in the future?
Well, one of the problems with technology is that the law has to be somehow ahead of the technology. It can't be lagging behind. And if I could give one example, the ADJR Act talks about a decision. And there was a case of Pincherich where the federal court said the decision doesn't include an automated decision. Now, I'm summarising that quite broadly, but that's one of the key recommendations we make in our article, that the notion of decision and also the meaning of reasons for decision in the ADJR Act and its common law equivalent should be revitalised. In light of the fact that more and more decisions in our public authorities are being automated. So that's a very specific example, but again, holistically, we felt that there has to be a more systemic view taken of public law and the public law institutions to ensure that when automation has commenced or is being planned, that administrative law values and human rights values are assessed at that design process, and then all the way through that administrative and public law is assessed through that process. So, for example, to have a proper review process, to have the meaning of decision expanded to include automated decisions.
Great, thank you so much. That's such an interesting answer, and certainly something that we will need to consider as we continue moving into a technological world. I'm really appreciative of the time that you've taken to answer this question for us. And I hope that the audience has enjoyed the response.
Great, thank you so much. And I hope everyone enjoys reading our article.
Our third author on show tonight is Mr. Julian Murphy, PhD candidate at the University of Melbourne and author of Legislating in Language, Indigenous Languages in Parliamentary Debate and Legislation in Australia. Julian, it's really wonderful to have you with us tonight. If I may ask, could you please provide a quick overview of your article for the members of the audience who mightn't have been able to read it yet?
Thanks, Interpretive, and thanks so much for including me in this issue. It's an incredible issue. So my article's on legislating and parliamentary debate in Indigenous languages. The focus is on Australia, but the article provides sort of a comparative perspective on things that are happening in other countries, including Canada and New Zealand, and then seeks to draw on that knowledge and bring it to bear on how Australia is currently legislating in language and how we might potentially do it better.
Great, thanks so much for providing that. If I may ask you a question now. To revitalise legal authorities is to introduce new vigour into the capabilities of the law for future practice. How is your article related to that pursuit? And in what ways do you consider that the law can accommodate bigger and better things in the future?
So, at its heart, my article is about, I guess, getting new voices into the legal process, whether that's in parliamentary debate or actually in legislation and the way that we read legislation, interpret it and ultimately apply it in courts and outside courts as well. And so I think when you talk about, for me, my article connects to the theme in the way that it's revitalising these really old institutions, colonial institutions for the most part, and if not subverting them, at least reorientating them in a different way to bring in Indigenous voices in particular, and the sort of knowledge that those voices necessarily bring with them. And I think sort of in very practical terms, the way that I see my article contributing to this project of sort of revitalising institutions is through a comparative perspective, bringing to light and bringing to bear the knowledge of Indigenous people in other countries and how they've made changes in those institutions. And also, of course, trying to foreground the work and progress that has already been made by Indigenous people in Australia, and really foregrounding those voices. One thing I tried to do in the article, apart from drawing on Indigenous language scholarship, was to use a lot of Indigenous language parliamentarians who've been advocating for changes in Australian lawmaking processes.
Great, thank you so much. That's really interesting. And for yourself, I assume that seeing Indigenous languages represented in legislation would be a really brilliant thing, and I'm sure for First Nations peoples and for the broader community as well. How do you see that process being undertaken?
Well, I spent about 5 years in the Northern Territory, sort of on and off, and that's where I first saw that process occurring. Mm-hmm. There's been some incredible steps made there. There's still quite a way to go by Indigenous parliamentarians trying to and ultimately being able to use their language in parliamentary debate with the assistance of an interpreter on the floor of Parliament. There's also some sort of contentious examples of that happening in the way that the institutions responded to that, and some of those are addressed in the article. But I guess that's the way that I first saw it happening, and I know it's happening in other parliaments around Australia as well. I'm now back in Victoria at the University of Melbourne. And interestingly, I think since the article was actually printed, there's still developments in this area, and Victoria's recently passed a statute that is actually the Great Ocean Road and Environs Protection Act, which is actually, I think, the first trilingual Australian statute, which has got a preamble in English and 2 Indigenous languages from the Great Ocean Road region. So it's happening in lots of different ways around Australia, and one of the exciting things about researching in this area is it's such a dynamic area with so much developing before our eyes.
Great. Thank you so much, Julian. And I really appreciate you taking the time to answer those questions for our audience.
Thank you.
Last, but certainly not least, we have Associate Professor Rosemary Langford from the University of Melbourne speaking tonight. She is a rather special author in this issue, as she has published 2 interrelated and successive articles, the first entitled Purpose-Based Governance, A New Paradigm, and the second entitled Use of the Corporate Form for Public Benefit, Revitalisation of Australian Corporations Law. Rosemary, thank you so much for joining us tonight. Would you please sum up first your 2 articles?
Thanks, and thanks for having me. So the first article proposes a model of governance centred on purpose. I call it purpose-based governance. This, I think, offers the potential for refocusing and reinvigorating governance. In the article, I show that the charity sphere leads the way in demonstrating the central role that purpose can have in governance and regulation. Given that charities are required to specify and stay true to their purposes for registration and tax reasons, governance in the charity sphere is naturally grounded in purpose. This clear role of purpose in the charity sphere, I think, shows how purpose could play a defining role in the corporate sphere. The gateway in this sense in the corporate sphere is articulation of purpose in the company constitution. I think giving purpose more of a role in the for-profit sphere has exciting potential, particularly in relation to the vexed question of stakeholder interests. The article also looks at fiduciary theory and demonstrates that the fiduciary model adapts well to a purpose-based rationale. It also shows that purpose-based governance doesn't disrupt accountability structures. All in all, purpose-based governance, I think, offers significant advantages in the charitable and for-profit spheres and beyond. I wrote the second article, which has revitalisation in the title, specifically with the theme of this journal issue in mind. So I specifically looked at revitalisation in the sense of revitalisation of Australian corporations law to allow purpose-based companies. The background, of course, is the increasing demand for appropriate vehicles for the conduct of social enterprises and other purpose-based ventures. This has seen a number of jurisdictions introduce special purpose legislation, which Australia hasn't done to this point. The article details the way that Australian law is already being revitalised to facilitate purpose-based companies. It follows on from the first article, delving deeper into relevant aspects of the corporations law regime, particularly the issue of moulding directors' duties for purpose-based companies, challenging issues of the application of the best interests rule where companies have multiple purposes. That in turn, of course, has flow-ons for the drafting of constitutional provisions. Other issues that I look at briefly are standing and enforcement, departure from purposes and signalling. The article also shows that the experience of overseas jurisdictions is actually a rich source of inspiration and guidance because these jurisdictions have confronted multiple issues in enabling purpose-based companies. So all in all, the article shows, I think, that Australian law is already being revitalised and that this is feasible. Indeed, it's opportune. It doesn't require a fundamental shift. Rather, because of the way in which the corporate form has developed and the malleability of directors' duties, it's really a natural progression.
Thank you so much for providing that overview. I think you've answered part of my question, but I'll pose it to you anyway. To revitalise legal authorities is to introduce new vigour into the capabilities of the law for future practice. How is your article related to this pursuit? And in what ways do you consider the law can accommodate bigger and better things in the future?
So those are really deep questions, which have caused me to think a lot. So as I said, my articles do demonstrate revitalisation of Australian law to give purpose more of a role and the exciting potential. This in turn, I think, introduces new vigour into capabilities of the law for future practice in a number of ways. First, the articles show how Australian companies can pursue purpose despite the fact that we don't have special purpose legislation and that our statutory best interests rule hasn't been amended to give directors more leeway in relation to stakeholder interests. At the same time, my second article shows that if we do introduce special purpose legislation, there's a rich array of overseas models to draw on, and we can pick the best aspects of these models and avoid the pitfalls. So the advantage of having waited so long is that we can critically analyse the strengths and weaknesses of these other models and introduce new vigour if and when we do enact special purpose legislation. Secondly, the articles show how directors' duties can be invigorated and adapted for purpose-based companies. Third, purpose-based governance has the potential to be a basis for an underlying governance paradigm, and that in itself, I think, would introduce new vigour into the capabilities of the law for future practice because of its advantages across a number of types of entities. Finally, fidelity to purpose has exciting potential to bring new vigour to fiduciary law. So I think there's a number of ways in which this revitalisation can and is introducing new vigour into the law.
Thank you so much, Rosemary. That's such an interesting topic, and certainly I'm looking forward to seeing purpose take a greater role in Australian corporations law. I really appreciate you taking the time tonight to speak with me. And I hope that the audience enjoys your response.
Thanks so much.
That wraps up the author Q&A session for tonight. We are very grateful to each of the authors that has participated for giving up some of their time to record these segments in advance, and hope that you have found their articles and responses equally as interesting as we have. Copies of all the articles published in issue 43.3 of the journal can be found at our website, www.unswlawjournal.unsw.edu.au, for some post-launch binge reading. No doubt the rest of the articles published in the issue consider other exciting ways in which the law may be revitalised, from argument that Australian public servants should be afforded more liberty in respect of their freedom of speech in response to the case of Comcare and Banerjee heard in the High Court of Australia last year, to considering the example of legal reform in the context of reproductive rights being achieved through the statutory enactment of abortion clinic safe access zones. To end, I'd like to thank everyone else who has participated in the launch event tonight. Antonia Zhu, Executive Editor of the Journal, Katrina Rathi, Partner in Charge at King & Wood Mallison, Sydney, the Hon Robert French, former Chief Justice of the High Court of Australia and present Chancellor of the University of Western Australia, and Professor Andrew Lynch, Acting Dean of the UNSW Law Faculty. Thank you also to you, our audience, for joining us tonight. Although I can't say that this is how our launch events typically run, we are very glad to have been able to celebrate the launch of this issue with you tonight. From wherever you are tuning in, I hope that you have enjoyed the launch and that you enjoy the rest of your night.